Hello students, welcome to Bhadra IAS Academy. Today in this topic we will discuss about a very important topic of judiciary, that is court of record. And this topic is important for your GS2, that is Indian polity. So first let us see what is court of record. Okay. So in this slide you can see, for a court to be considered to be a court of record, this court shall fulfill two important conditions. The first condition is the records of the court shall be admissible as evidence in any other court of India. Okay, means the records of the court, suppose records of Supreme Court, records of High Court, these records shall be admissible as evidence in any other court of India. Okay, and second criteria, the court shall have contempt of court jurisdiction. Okay, means if anyone disobeys the orders of the court, if anyone tries to hamper the prestige of the court, then court shall have the power to punish that particular person for its contempt. So in India, if any court fulfill these two conditions, then that court is considered to be court of record. And if you see, in India, only two courts, that is Supreme Court and High Court, fulfill these two criteria. Okay, and that is why Supreme Court is a court of record under Article 129 and High Court is a court of record under Article 215. Okay, and these two articles are very important. Remember these articles. Okay, Article 129 and Article 215. Okay, so here you can see contempt of court. This contempt of court is very controversial. Okay, and this contempt of court has number of criticism also. So let us see why contempt of court has been criticized. The first point you can see, oversensitivity. Okay, because during contempt of court, there is sometimes see that the judges of the court, that is judges of Supreme Court or High Court, they show oversensitivity in punishing the individuals. And second point, there is inconsistency in the application of contempt of court jurisdiction. Means sometimes you may do something which may not hurt the ego of the judges and you may not be punished, but sometimes I may do the same thing and the court may punish me for that particular activity. But if you see, this is inconsistent, because you have done the same thing, I have done the same thing, but you have not been punished but I have been punished. So this is very controversial, means it is very inconsistency you will find in the application of contempt of court jurisdiction. And third, this contempt of court, this violates principle of natural justice, because according to principle of natural justice, no person shall be punished unheard and no man can be the judge of his own case. But during contempt of court, when I am being punished, then the judges does not hear me or does not hear my viewpoint or does not give me opportunity to provide anything as a defense. So ultimately this is violation of principle of natural justice, and at the same time the judge is the judge of his own case. The same judge is the judge of his own case, and this is also violation of principle of natural justice. Okay, and that is why this contempt of court is criticized by many individuals. Okay, that's all for today. Thank you.